interesting discussions at your workshops. I don't have a PowerPoint presentation. I also don't have any notes. The reason I don't have any notes is because I've learned now a number of conferences is that if you're not the first one at the conference, what you're going to say has really changed by the time it's your turn. Same thing happened here. I had things I wanted to say last night, and this morning I would have been preempted by what Jane said, what Kate said, and very much what Nancy said. So I have going to say different things I wanted to say last night or this morning. Secondly, I don't use notes anymore because, as a bit embarrassed to admit, I'm getting the age now, I can't not read my notes anymore. So it is much easier to talk to you. The topic of this part of the workshop is new developments in refugee law. And like Nancy and I agreed that she will look at the case law in Canada on exclusion 1FA, while I will look at the rest of the world, which actually is not the entire world. It's actually, I'm not going to discuss the US, we have occasionally done that. Canada's done by Nancy. I'm going to look at 6 other countries, namely Australia, New Zealand, the UK, and the European continent, Netherlands, Belgium, Germany, and France. And like Nancy, in order to tell you what new developments are, I have to situate first what the actual rules were before those new developments occurred. And what I want to especially look at is the interaction between international law, specific international humanitarian law, international criminal law, and 1FA. After all, as pointed out by both James and Kate, 1FA talks about a person who has committed crimes against peace, war crimes against humanity, as defined in international instruments. There's a direct connection to international law, but international humanitarian law, as Kate said, or international criminal law. So I'm looking at the case on those countries and how they have applied international law, or in some cases have not, and whether it's a good or a bad thing. And I want to divide the topic in two aspects. The reference in 1FA to international instruments is clearly connected to the crimes set out in 1FA, namely crime against peace, war crime, and crime against humanity. So what you have seen in those 6 countries, including Canada and some respect not the United States, is that decision makers in asylum have made from early on connections to international instruments. And depending on when they issue the decisions, those connections have been made with, initially with the IMT, International Tribunal in Nuremberg, and as time went on, they made connections with the ICTY, ICTR, and now the ICC. Now, what's interesting is that when the convention was drafted in 1951, and it was put in there, the drafters were the view that instruments would only refer to international treaties and possibly soft law like the International Law Commission's work. They had no clue, they had no appreciation that 60 years later there will be a huge body of jurisprudence out there interpreting international instruments, which makes it very complex, very difficult for decision makers, some decision makers, to actually interpret what international criminal law has to say about the exclusion ground they're applying. And let's not forget, unlike the specialized judges at ICTY, ICTR, Sierra Leone Special Court, the ECCC in Cambodia, as was pointed out, I think, by Kate, in the United States, that between 0.3 and 0.5% of the decisions in asylum cases deal with exclusion. That number is echoed in Belgium as a result of research done by Juris, in France, in Holland. Exclusion is about 0.5% of all asylum decisions, which means that when the asylum decision maker gets exclusion, is a very unusual situation. They see it maybe once, twice a year in their work, in their practice. Which means if they have then to enter and look at information that is decided by international tribunals, it's a huge task. And there's one of the dilemmas that I think decision makers and the people who train them are faced with right now. There's a huge body of law out there, and you have to decide how to incorporate that in the daily practice of decision makers, which is not very difficult. Plus, it was I think Jennifer mentioned that point, there's also the issue that international criminal law is not consistent with itself. Decisions with ICTY, ICTR are not consistent with what ICC is coming up with right now. There's a difference. So what law do you apply? So a number of complicating factors. Having said that, the application of 1FA by the decision maker in those 6 countries, as well as Canada, in terms of determining what amounts to crime against peace, what amounts to war crimes, what amounts to crime against humanity, has been actually quite consistent. Have been quite consistent with international criminal law, and be consistent with the decisions in those 6 countries. For instance, on the issue of war crimes, one of the most difficult aspects in the last couple of years is to determine whether war crimes can be committed in what I call non-international armed conflicts or civil wars. That has been addressed. It's now the Rome Statute. Rome Statute 2002 made it very clear you can commit war crimes in civil wars. And a decision by ICTY called Tadic said the same thing for a situation occurring in 1991. But as you all know, there are cases before asylum seekers which go back before 1990 in civil wars. And decision makers in the Netherlands, in France, in Canada have consistently said, by relying on IHL, on ICL, to say that generally speaking, you cannot commit war crimes in civil wars if they happen before 1990. And what is interesting, they said that even without looking at the jurisprudence of the ICTY. What they did, they looked at the ICC statute and then extrapolated back in time a little bit. And there's another theme I see when decision makers, established decision makers, look at the crimes on the 1FA, is that there have been a number of occasions where they made statements about the components of those crimes, either international components or the crimes themselves, where they actually came to a conclusion which they did not rely on international criminal law, humanitarian law, but was actually very consistent with the reasoning given international tribunals. And I think that's not surprising in itself, because great minds think alike everywhere. So I mean, the fact that people in an asylum situation, the judge or the tribunal decides that, for instance, a policeman is part of a civilian population as part of our humanity. And as explained, Mugesera referred to international criminal law, saying what the elements of crime against humanity were. One of them is the victim as a part of the civilian population. Australian court said that a policeman in Nepal who was attacked by the communist Marxist-Leninist party was part of the civilian population. Therefore, when this Nepalese person came to Australia, was found to be excluded of crime against humanity because the attack against the police person was part of the civilian population. That was done in 2006. In 2009, the Sierra Leone Special Court said the exact same thing in the context of Sierra Leone. So you see that at the local level, the Australian court already had the same views about the police being a civilian population and the National Tribunal 3 years later. A Dutch court, against the situation in Nepal, made it very clear that what they call village heads in Nepal, who worked for the government, were not part of a combatants group, were also civilian population. Again, there was no reference at all to international criminal law, but if the same situation would have occurred, I dare say, for the ICTY, ICTR, we've come to the same conclusion for the same reasoning. So that's another example where you see domestic institutions expressing themselves in international criminal law in a way that is very consistent with what international law has said or would have said. More interesting is that the crime against peace, which has been rarely used, now known as aggression, both a manual in the Netherlands, Dutch refugee law of the interpretation of publicity is regulated to a large extent by a manual in Holland more than jurisprudence. They actually give a definition of aggression in 2005 was in effect followed by the Kampala conference, was a review conference in Kampala last year, to actually define what aggression means. It's not part of the ICC statute. The Dutch manual already was very prescient in giving an exact same definition. Same thing, a Belgian case had to decide whether or not a person belonging to Kabul in Ethiopia that invaded Somalia in the early 90s was part of the crime of aggression, and indicated it was, without looking at international criminal law at all. So again, you see on the notion of what crimes are, the component of crimes are, domestic decision makers have been very consistent with international law without even relying on it. On the underlying crimes, you have, like for workers' crimes, you have international aspects to it, and also underlying crimes. You see the same aspect. You see that, well, originally, as a matter of fact, decision makers, when they looked at the crimes, crimes, managed war crimes, they typically looked at organizations that were involved in murder or torture. As time went on, they started getting involved or looking at a crime which is a bit more obscure, like inhuman treatment, inhuman acts, rape, persecution. And in doing so, you see the same trend. They would actually define particular crimes without looking at international criminal law, but still being very consistent. An example of that is, for instance, where an Australian appeals court looked at the crime of torture and whether a victim of torture had to be under the control of the perpetrator, and what kind of control it had to be, factual control or judicial control. And the court says factual control is sufficient. Again, it was reiterated later by the ICC in a case. So, in other words, the decision makers on the asylum side do know what they're talking about, even though they don't have much information. However, and this was another example, I should say, that the German court, the highest administrative court, had to decide last year on whether the war crime of, I forgot the name now, the war crime of concealing a weapon, the crime of concealing a weapon amounts to a war crime. Sorry, treacherously killing somebody, like concealing a weapon. And that court actually looked at the jurisprudence of the ICTY, and the ICTY said they could not find anything. It's a new crime, and there's no jurisprudence. So they actually looked at international military law themselves and defined the parameters of this particular crime in a way that I think would do any international tribunal proud, that kind of analysis. So always to say, while there's a lot of jurisprudence out there, so far, in most situations, I think that the national tribunals have been very competent in determining what the parameters of international crimes are in 1FA. Now, having said that, there's also been exceptions. For instance, where an Australian tribunal was of the view when in Zimbabwe the Harare was cleaned out of people who were squatters, which is not to be crime against humanity, which would not be consistent with the crimes of the forced displaced as now done by the ICTY. But on the whole, you see a good development where the decision makers at national level do set out parameters which will be consistent if the national tribunals will look at it as well. However, so this is getting more and more complicated, and there's more and more case law out there. So while so far, whether it's been luck or competence or just common sense, so far the national decision makers have been quite consistent with international criminal law. That might change when they start looking at more and more obscure war crimes. And don't forget, there are now over 50 war crimes contained in their own statute, and some of which are really, really obscure. So they probably would benefit from actually addressing or looking at international jurisprudence. That's on the issue of the crimes. Nancy talked about the notion of extended liability in 1FA, the word committed in 1FA. And what you see there is that until 2009, national decision makers did not rely at all on the national jurisprudence. They developed their case law not independently in the sense that they did it without any benefit from other jurisdictions. What they did, they would look very much at other countries. Nancy mentioned, and so did James, the Ramirez case, the 1992 Federal Court of Appeal case in Canada. That case has had a great deal of effect internationally. It has been quoted in Australian case law, it has been quoted in New Zealand case law, quoted in UK case law. Interestingly enough, if you look at Belgian and Dutch jurisprudence, the cases are written in Dutch, but they still use the term personal and no participation in English to explain what kind of concept we're looking at. So this case has profound impact on other decision makers. What happened after that, most decision makers started to start using the notion of personal participation and develop their own context, their own contours of what that meant. And you see, on the whole, very little interaction between those decision makers after the initial reference to Ramirez. By the way, Ramirez, relied on US case law, like Fedorenko. So it was also not done in the abstract. So what you see that those decision makers have looked at complicity primarily by building on personal participation and looking at three types of complicity. One is, and I can refer to Nancy, one is the membership with organizations. One is what is equivalent to the criminal concept of aiding and abetting. And the third one is the notion of common purpose, which James referred to Pierce and Belly as referring to JCE, International Criminal Law. But all those notions have been developed in isolation until 2009. But what you see, though, comparing those jurisdictions, and whether it's the result of looking at Ramirez originally, whatever it is, or they think alike, is that the jurisprudence in how to apply the notion of aiding and abetting and common purpose have been, again, very consistent, both in common law countries and countries in the continent. For instance, and by the way, the reason it did not look very much at international criminal law is that international criminal law has not examined a great deal of cases dealing with complicity. The reason is that all those institutions have limited budgets and only go after the people most responsible, the big fish. Now, complicity is designed for the little fish. So at the ICTR, for instance, we had only 2 cases where someone was convicted for complicity, as opposed to criminal responsibility, or JCE, or direct involvement. So as a result, you see development at the national level of what amounts to aiding and abetting, what amounts to common purpose, based on the situation before that, which is a very, very rich environment. For aiding and abetting, for instance, they repeat or they set out the same principles at the national level, namely, you have to make substantial contribution with the knowledge of the crime. But how it applies situations is much broader at the national level. It has been applied to situations, and by the United States, such as handing over people to organizations where they would face a bad fate, or handing over information to organizations where people were either tortured or killed. That has been found to be aiding and abetting. Same thing with common purpose. Common purpose has been described in different ways in common law countries and also at the continent. But the main aspect that countries be looking at, decision makers be looking at, is okay, we're looking at a situation whereby we cannot prove this person made a substantial contribution. However, information before us is such that the person is so close to the bad things happening that the person must have been guilty. I always explain in training it's sort of like the duck approach. If it looks like a duck, looks like a duck, it must be a duck. The person is part of a group. The group is involved in crime against humanity, war crimes. You cannot pinpoint individual liability, but together, bad things were caused by this group. So therefore, the person must have been involved, must have been guilty of something. That is sort of the basic premise of common purpose. Now, what most countries have done, again, depending on each other, is to say, okay, how can you place a person close to those bad activities? And look at a number of factors. The factors, as Nancy, well, it's just gone, but she had 6 factors there expressed in Canada. Some of those factors are also repeated in other countries. France, for instance, is very strong that if somebody is not an aider or a better, but belonged to the organization for a long time and did not dissociate himself, the person is guilty, is excludable. In Holland, they look very much at high persons and the influence that person had on the actual outcome of an organization's involvement in against humanity. So they look at a number of factors to say this person should be found excludable. That was all done without any reference to international criminal law until 2009. In 2009, the case is referred to JS. She actually should refer to the JS case of the United Kingdom Supreme Court, but 2009 was the Court of Appeal in the UK that for the first time looked at the connection between 1FA and international criminal law in the area of extended liability. And in my view, did a superb job in setting out all the different forms of liability contained in the Rome Statute and set out by the ICTY jurisprudence. And again, the conclusion, by the way, JS was a Sri Lankan person, part of the Sri Lankan army. He was the chief of intelligence at the end of his career and also a bodyguard of the main leader. He was included by the British UK Appeals Tribunal, was overruled by the Court of Appeal and later by the Supreme Court of the UK. In terms of liability, the Court of Appeal looked at what the Rome Statute says in terms of external liability and also what joint enterprise has been developed at the ICTY, especially ICTY. The Supreme Court did a similar analysis in 2010, March 2010, looked at international criminal law, looked at the law of common law countries like Canada, Australia, and New Zealand, looked at UNHCR submissions, by the way, UNHCR guidelines, all of this, and they defined complicity in a slightly different way than before. They say, for instance, membership is not a heading that we condone in refugee law. However, you can use aiding and abetting, you can use command responsibility, and you can use also JCE. So that was followed, similar analysis by the New Zealand Supreme Court in August 2010. Look at international criminal law, and again looking at a case called X and Y. Again, a Sri Lankan person. Also follow international criminal law. And in March of this year, the German Legislative Court looked at international criminal law in order to define what command responsibility is. So what you're seeing is that some courts, higher courts, the highest courts, are now looking at international criminal law and say that's what you should be looking at, decision maker, if you want to apply 1FA. How useful is this trend? I think it's very useful because it will provide, there's been consistency already, but you saw some divergencing happening in terms of the facts. Relying on one body of law, of course, should promote consistency. However, having said that, consistency can only follow if the decision makers setting out the criteria do that in a reasonable and impeccable way of reasoning. And in my view, the JS case in the UK, the Supreme Court, is not the best reasoning for international liability. I think the fact that they rejected membership, I don't think is convincing, the argument. The fact that they insist that people use the concept of JCE, which is a very complex concept, even international criminal law, is difficult conceptually, it's also difficult to prove. As an example, at the ICTY, when they use JCE a lot, they typically bring in dozens and dozens of witnesses, and even then they're always successful. In my view, this notion of JCE, the actual conceptual analysis as set out and recommended by the UK Supreme Court, does not work very well in refugee hearings, because as Nancy explained, a typical refugee hearing is half a day, exclusion half a day. You only hear the person himself, and you hear country evidence. For JCE, one of the elements, which by the way, in the excerpt from James of Pierce and Belly was incorrect, and I think Pierce and Belly got incorrect, not you, James, is that you need to prove that a group of people have an intention to commit crimes. How do you prove intention of more than one person? You have to bring those people, or you bring other people. it's virtually impossible in most cases in refugee law to actually prove common intention. However, since JCE bears quite a bit of resemblance to this six-factor approach, the factor approach has been accepted already by national jurisdictions, it's my view that keeping to use those factor approach will not take anything away of the analysis in terms of the common purpose. So to conclude this, while there's now internationally at external liability attempts to use international criminal law, I think those attempts can definitely be used for aiding and abetting, for command responsibility, but it's less successful for JCE, and I think it's better to use common purpose. Issue of membership, I'm running out of time, but there's a whole membership. I said briefly, what has happened is while the UK Supreme Court rejected the issue, it's still alive in New Zealand, it's still alive in Canada. There are some cases in the United States, while there is some lip service paid to this notion. Germany, in this case of March, seems to suggest membership can be used. The Netherlands has a very interesting approach whereby legislatively they have decided that certain functionaries can be excluded unless they have a rebuttable presumption. So it's only France and Belgium in this overview that has definitely rejected the notion of membership, and now it's the UK Supreme Court. But it's interesting to note that the Ramirez case, the very prominent case, decided to use membership because it relied on the IMT, the Nuremberg Tribunal decision in 1949, which actually used membership as a form of liability. So to me, I don't think membership is more robust yet. So in conclusion, I think it's good to have decision makers look in asylum cases in international criminal law, but I think there's a limit how far you can go, taking into account the nature of refugee decisions. Thank you.
Thank you very much, Joe.